I ask?
Well, we're not aware of it. You don't usually allow witnesses to testify, and we'll give them whatever weight is appropriate. They do nothing, but we certainly want to follow them. So we're going to try and keep it as brief as possible. I assume you will.
Is it affirmed that he's an expert as well?
Yes.
And if that's accepted to the board?
I don't agree with that. I don't agree that he's an expert. I mean, he can give his opinion and we'll give it the way we think it deserves.
And I'll review his credentials.
Yeah, I'll put it on there.
That's fine.
The resumes are in the folders, in the file.
Mr. Pimentel, just to go over a little bit of your background. Can you please tell the board your educational background?
I have both a bachelor's and a master's in urban planning, and I'm a nationally certified planner.
And what's your present occupation?
I'm the zoning official for the city of East Providence, as well as I own my own consulting firm.
And how long have you been employed as a zoning official for the city of East Providence?
A little over 10 years.
What, in your position as a zoning official for the city of East Providence, can you please explain some of your duties and responsibilities?
Sure. Interpretation of the respective zoning regulations, enforcement of the regulations, staff to the zoning board review, assistant scripting, amending the ordinance, scripting new regulations.
Okay. And where did you graduate from? Did you get your bachelor's and master's degree from?
Bachelor's from the University of Rhode Island. Did most of my studies kind of graduate level at the University of Florida. Completed my studies at the University of Rhode Island, obtaining a master's.
Completed my studies where?
I'm sorry, completing my graduate studies at the University of Rhode Island, obtaining a master's in urban planning and community development, and then 1996 studied for the national examination to be a nationally certified planner.
And you now hold that credential?
I do.
And have you ever had the opportunity to testify as an expert at similar zoning type hearings?
I've testified probably before 95% of the cities and towns, zoning, planning councils, on a variety of issues. I would say 2/3 of my work is zoning variance related, another third is development related. I've also testified in Superior Court, Newport, Washington, Kent County, and I've also been involved in a compliment in which I was quoted before the Supreme Court.
And were you admitted as an expert in all those circumstances?
I was.
And have you ever been admitted as an expert before the time of Jamestown?
On several developments, I believe, on several developments, the majority of them being development of prior recorded lots.
And if you were permitted to testify as an expert this evening, what type of testimony would you present, and how would your expertise assist this board?
I'd be providing my professional opinion in regards to the clarification of exactly what the use that's being sought is. There's been terminology thrown around regarding accessory, and non-conforming use, and in fact, there's been two different opinions provided between both councils. One determining it's not a non-conforming use, one saying it is. I try to clarify those points based on my professional opinion.
And would you also provide testimony concerning the existing property conditions?
The existing property conditions as they relate to the neighborhood, I did do an in-depth analysis at your request. I looked at a total of 99 lots, 47 in the R20 district, and then 52 plus in the R8, simply because this is a split zone neighborhood directly down Standish.
In your opinion, would be valuable to this board as an expert in this area, having qualified previously as an expert, in what way?
Once again, providing clarification in regards to the ordinance, and also as to how it comports with the comprehensive plan, which, by the way, is one of the burdens.
I would ask that my witness be admitted as an expert in this particular category.
Well, I know someone on the board is next to me. I don't see.
I just want to clarify my objection.
Sure,
I have no problem with him testifying to the analysis he did. To the extent that he's going to be giving legal opinions, though, that's not for him to give. And we could have our own legal opinions after hearing arguments from counsel.
Yeah, of course. Yeah, that's
That's what I'm concerned
So, being duly admitted as an expert, I'll proceed. Mr. Pimentel, I retained your services for this evening, and can you please explain to the board why I retained your services?
Sure. Your client, being your father, lives directly across the street. He's clearly got standing. He's been on a bottom. He received notice. And his concern was, A, how this comports with the zoning laws and the comprehensive plan, and from a land use perspective, the impact. And how it, once again, comports with the regulations, given that it's a non-conforming use and it's being expanded by special use.
Now, you have the opportunity to examine the existing property conditions on Standish Avenue, 23 Standish Avenue. Can you please tell me what your investigation revealed regarding the existing property conditions?
Well, right now you've got two separate residential structures on one parcel, which, by the way, is not permitted under your regulations. It's on page 5 of 13, but pursuant to section 82-303 of your ordinance, it states that not more than one principal residence shall be permitted on any lot in the residential district. In this case, we have two principal residential structures on one parcel. It is true that it is a pre-existing non-conforming use of predates zoning. My research believes that the property was improved in the 1920s, which predates zoning. But the reality is, it right now is a non-conforming usage, something that the current property owner and previous property owners are enjoying. That's a benefit that other residents don't have the right to enjoy, and that's why it's deemed non-conforming.
Can you please explain to me what a through lot is?
A through lot is a property that does have two frontages on a public right-of-way, but which do not intersect. When two streets actually intersect, then we define it as a corner lot.
And in this particular circumstance, are there additional zoning requirements for dimensional relief when you have a through lot?
Yes, as the zoning office, enforcement officer for the county Jameson has noted, that pursuant to the regulations, when a property has more than one frontage, every property boundary that actually comes on public right will be treated as a frontage, and therefore incurring in the R20 district to get rid of the first setback.
And it's my understanding that they would also be asking for relief from that dimensional setback too in this application, is that fair to say?
They have noted that they need dimensional relief from that. In disagreement with the side yard, they keep talking about the accessory setbacks. I would argue this is a secondary principal structure on this parcel.
Okay, maybe you can explain that to me, the difference between, under the town zoning ordinances, the difference between accessory dwelling and what you're terming as a second residence.
Sure. Pursuant to section 82-103, which is the definition section of the County of Jamestown zoning ordinance, I would quote, I'm sorry, I apologize, 6 of 13. An accessory dwelling unit, a subordinate dwelling unit / apartment, so it's a subordinate dwelling apartment, having no greater than 600 square feet of living area, and sharing ownership and utility connections with the principal building that may or may not be within an outbuilding or accessory building. Now that's what the definition of an accessory dwelling and accessory apartment is.
So does this particular unit fit that definition?
It may very well, if it wasn't for section 1400 of the ordinance, accessory apartments. So you take section 1400 accessory apartments, you relate it back to what is the definition of accessory apartment. Section 1400 notes that an accessory apartment will only be permitted if it's in conjunction with a permissible two-family or multi-family dwelling. Well, it's clear in the R20 district, pursuant to the use schedule, that neither a two or multi-family dwelling is a permissible land use in the R20. It is allowed by special use, but it's not permissible. So therefore, clearly, you couldn't have an accessory apartment because it would have to be in conjunction with permissible use. Those uses are not outright permitted. So therefore, you cannot define this as an accessory use. The only other option is to define it as a secondary principal structure on the property. It's another dwelling unit.
And what type of relief would need to be requested if this board saw that your definition was correct?
Well, as the board has been bringing out all night, pursuant to section 82 and 703, now we're talking about non-conforming uses. Clearly, this would be a non-conforming use.